Welcome to International Trade Minute Quickfire Trade News, the essential podcast for today's trade professionals, presented to you by Renewal Law Firm. If you're a seasoned practitioner, this is where you'll find your weekly distilled briefing on the pulse of international commerce and regulation. We bring you the latest legal and trade news, distilled into straightforward, bite-sized updates for busy trade professionals. Sponsored by Renewal Law Firm, this podcast is crafted by expert trade attorneys to keep you ahead of the curve with concise, actionable insights. Perfect for your morning commute or coffee break. Stay informed without the fluff. Subscribe now on Apple Podcasts and Spotify, and join our professional community on LinkedIn. Today, we'll be exploring key updates in international trade, including doubts surrounding the renewal of AGOA, a pivotal ruling by the D.C. Circuit Court on aiding illegal imports, a landmark clarification on the U.S. law against email smuggling, and a significant fine imposed by OFAC for violating Russian debt restrictions. Let's get started and dive into these critical developments shaping the trade landscape. Today, we begin with an update that has everyone talking. The renewal of AGOA, or the African Growth and Opportunity Act, appears improbable for 2024. Assistant U.S. Trade Representative for Africa, Constance Hamilton, along with Deputy Assistant Secretary of State Joy Basu, recently addressed these concerns. They emphasized the anxieties surrounding the timing of the renewal and the uncertainties about which countries will maintain their eligibility. During a press conference hosted by the State Department's African Media Hub, much of the discussion revolved around Ethiopia's quest to return to AGOA eligibility. Hamilton was clear that the U.S. has been very specific in communicating what actions Ethiopia needs to take to regain this status. This expectation stems from ongoing issues, including human rights violations cited in the AGOA biennial report. The report highlights continued credible allegations of extrajudicial killings, arbitrary detention, torture, and restrictions on freedom of expression within Ethiopia, painting a grim picture for its immediate eligibility return. Hamilton elaborated that clarity and transparency are central, stating these countries are well informed about the steps they need to take and the ramifications of their actions. It's not a guessing game. Governments are given ample warning and precise guidelines to align with AGOA requirements. Despite this, some countries currently in breach of eligibility standards show little immediate likelihood of making the necessary changes. Crucially, Hamilton mentioned the potential impact on cross-border supply chains among countries, particularly those involving ineligible nations. She reiterated that it's the onus of these nations to initiate reforms, stressing that the U.S. remains engaged with those in trouble, but underlining that non-compliance signals almost certain removal from AGOA benefits. Turning to the broader legislative context, a renewal bill introduced in the Senate proposes alterations where violations of eligibility criteria might lead to partial rather than complete removal, among other adjustments. This could offer a more flexible approach, but also highlights the evolving complexities in managing AGOA's implementation. South Africa remains a topic of interest. While Hamilton acknowledged strong bilateral discussions with South Africa's trade officials, she cautioned that it's too soon to predict the country's future within AGOA. A South African journalist's question about AGOA's overall renewal for 2024 brought a tentative response from Hamilton. She conveyed confidence that AGOA will be renewed before its expiration in 2025, suggesting early 2025 as the most likely timeline. In summary, the fate of AGOA and the countries benefiting from it hangs in delicate balance. Trade practitioners should closely monitor these developments and prepare for plausible scenarios. As the renewal process evolves, staying informed is critical to leveraging the preferences AGOA provides or navigating the complexities that its absence might entail. Next up, let's delve into a significant ruling by the D.C. Circuit Court regarding the Plant Protection Act and Animal Health Protection Act. The court recently declared that entities must knowingly aid or abet illegal imports to be fined under these laws. In a landmark decision, the court overturned a hefty $1 million fine against Amazon, providing much-needed clarity on what constitutes culpable participation in unlawful conduct. To provide some background, this all began when the USDA fined Amazon for allegedly aiding in the illegal importation of plant and animal products through its fulfillment services. These services allow overseas suppliers to store goods in Amazon's warehouses, until they're sold and shipped to customers. The USDA claimed that Amazon's operation facilitated the unlawful imports, but the D.C. Circuit Court held a different view. Drawing from the Supreme Court's 2023 decision in Twitter v. Taamneh, the D.C. Circuit emphasized that civil liability for aiding and abetting generally requires conscious and voluntary participation in illegal acts. Simply offering a neutral service, like Amazon does, doesn't meet this threshold. The court pointed out that Amazon's fulfillment centers merely provided routine business services to third-party sellers, and there was no evidence showing Amazon knowingly contributed to the illegal imports. Furthermore, the USDA's argument hinged on a broader interpretation of the terms cause and induce, suggesting they should cover actions beyond conscious involvement. However, the court stood firm, stating that these terms, when paired with aid and abet, require a conscious, voluntary, and culpable participation. For trade practitioners, this ruling underscores the principle that providing neutral business services without conscious and willful involvement in illegal activities does not amount to legal culpability. It highlights the necessity of proving actual knowledge and intent in cases of civil liability under the Plant Protection Act and Animal Health Protection Act. This decision serves as a critical precedent for entities operating in complex trade environments. It reinforces the need for clear evidence of intentional participation in illegal activities before imposing substantial fines and penalties. In essence, trade practitioners should continue to ensure compliance, but can take a bit of solace in the fact that neutral business operations, absent knowing involvement in unlawful acts, do not constitute civil liability under these statutes. In our next story, we dive in a landmark decision. A federal court in Kentucky has clarified that U.S. laws barring export smuggling cover only physical items, not emails. This pivotal ruling arose from a case involving defense contractor Quadrant Magnetics, which was accused of smuggling weapons out of the U.S. The specific allegation was that Quadrant smuggled goods by emailing magnet schematics to Chinese manufacturers. At the heart of the case was 18 U.S.C. Section 554, a statute prohibiting the unlicensed export of any merchandise, article, or object contrary to any law or regulation of the United States. U.S. District Judge David Hale determined that the terms merchandise and object clearly refer to tangible items. As for article, Judge Hale noted that while dictionary definitions could be interpreted more broadly, the context of the statute, which is part of the Reducing Crime and Terrorism at America's Seaports Act of 2005, implies a focus on physical goods. Hence, article must also be understood as referring to something material. This interpretation is further supported by another legal principle, ejus dem generis, which means that when a law lists specific terms followed by a more general term, the latter should be understood in the context of the preceding terms. Given that both merchandise and object are tangible, Article 2 must be tangible. The court's decision reinforces that the scope of statutes designed to prevent smuggling at physical seaports naturally pertains to material goods, not electronic communications. This ruling is a critical clarification for compliance departments, emphasizing the need to focus on physical exports when evaluating compliance with U.S. anti-smuggling laws. As our last feature in today's episode, OFAC has levied a hefty $7.5 million fine on a Massachusetts-based financial services firm for flouting the Russian debt restrictions. The penalty comes down to the actions of its subsidiary, Charles River Systems, which was found to have altered invoice dates to dodge the Ukraine/Russia-related sanctions regulations. These violations, involving over $1.2 million worth of invoices tied to Russia's Sberbank and VTB Bank, were not voluntarily disclosed to OFAC and were deemed egregious. A core issue was the staff's evident lack of understanding or disregard for sanctions implications, which allowed these practices to persist from 2016 to 2020. This period includes the years following the introduction of sanctions after Russia's 2014 Crimea invasion, but before the more recent wave imposed after the 2022 Ukraine invasion. Although State Street acquired Charles River in 2018 and conducted a post-acquisition analysis, it didn't uncover these transgressions. The subsidiary's modus operandi involved changing the dates on older invoices to make them appear current, ensuring payment by U.S. banks that had started rejecting late payments due to sanctions compliance. OFAC discovered that Charles River regularly redated invoices, sometimes up to 6 times, to bypass the restrictions. These actions involved at least 18 employees who maintained minimal compliance procedures before being acquired by State Street. State Street's reaction included bolstering its sanctions compliance team by 25% in 2022, revising its global sanctions policies, and severing ties with the affected Russian entities by February 2022. OFAC highlighted that thorough compliance measures are essential, especially following mergers and acquisitions. State Street's upfront and detailed involvement with OFAC during the investigation mitigated the final penalty, which could have exceeded $13.5 million. This case serves as a critical reminder for trade practitioners. Robust compliance frameworks must be established and continually assessed, especially when integrating new entities. Awareness and adherence to sector-specific sanctions are non-negotiable in maintaining resilient and lawful international financial operations. Thank you for tuning in to International Trade Minute. We hope today's episode was insightful for your practice. This podcast is brought to you by Rydell Law Firm, your trusted partner in navigating international trade law. Don't miss our next episode. Subscribe now on Apple Podcasts and Spotify. Stay connected and continue the conversation with us on LinkedIn. Until next time, stay informed and stay ahead.